Okay. Good morning. This is a meeting of the Housing Subcommittee of the California Paraprofessional Program Working Group. I'll start by calling roll. Julie Falmouth.
Here.
Judge Harper.
Here.
Amos Hartston.
Here.
Fariba Sarouche. I don't think I've seen Fariba yet. And Ira Spiro.
Here.
Okay.
Shall we see if there's any public comment?
Yes. We have a number of members of the public who are in attendance. If anyone would like to make comment, please raise your hand. See, we have one hand raised. We can go ahead and start. I have a couple of hands raised. Judge Harper, did you want to set a time limit for public speakers?
I think 3 minutes would be appropriate since we do have some speakers waiting.
Okay. We'll go ahead and start with Jason Solomon. Hello, Jason.
Hi, thank you. Jason Solomon, Stanford Center on the Legal Profession. Just 2 quick points today, picking up on the discussion last time. One is in terms of thinking about how to define this recommendation and the scope. It seems to me there are sort of 2 different ways you can go about it. One is you can define the area broadly. You could say, for example, housing or landlord tenant. And then to the extent that you want to exclude anything underneath that, for example, the quiet title or whatever that may be, you could do that. The other way of going about it is to simply create a list of particular tasks. So you could say, for example, unlawful detainer, right, which is the category that people have talked about. I want to encourage you to go with the former, where you define it broadly and say housing issues or landlord-tenant disputes. The reason being, as one of you pointed out last time, it may have been Amos, forgive me if I'm getting that wrong. The reason being that you really want to try to capture as much pre-litigation activity as possible. The risk being if you just say we're talking about unlawful detainer action, that by the time, as Judge Harper and others with experience knows, by the time that eviction notice is filed, the unlawful detainer action is filed, the respondent, the tenant, really only has, I believe it's 5 days to respond, and so it really doesn't give them the opportunity to hire a paraprofessional, et cetera. So defining the area broadly will give it an opportunity to capture as much pre-litigation activity as possible so it can be resolved in advance. The second point I want to make is just about the goals and the metrics for success. If you look at the Shriver Project, for example, and the report that came out of that, some of the goals and the metrics that they were looking at were, are there more settlements? Are there faster resolution of cases? And so I think those are important things to keep in mind, as well as what you might think about as sort of the balance of power between landlords and tenants. Because if you have a situation where generally both parties are unrepresented, even if only one ends up being represented, that can provide benefits and that can be a success. Because if the judge has one person that they can talk to who knows the system and one person who is dealing with it in a less personal and emotional way, that can lead to a quicker settlement and a fair resolution for all. So that's what I'd encourage you to think about in terms of metrics for success. Thanks so much.
Thank you.
Thank you. We did have another hand up, but it looks like that person no longer has raised their hand.
I think their hand's raised again.
Oh, okay. All right, Brenton and Inoue.
Good morning. Yes, my name is Brenton Inoue. I'm the managing attorney of the Asian Pacific Islander Community Outreach Project at the Legal Aid Foundation of Los Angeles. And I'm urging the State Bar and this working group to reconsider its use of paraprofessionals in the limited practice of law and housing matters. There's a long history of notarios and unsupervised paralegals preying upon vulnerable immigrant communities in matters related to immigration, family law, and housing. And this expansion of allowing paralegals to engage in limited practice of law will further exacerbate this issue. As a staff attorney, I represented a domestic violence survivor in an unlawful detainer case where she was being evicted for making too much noise after her abuser found her and was beating her. She first sought the assistance of a paralegal who held himself out to be an attorney and prepared a baseless motion to quash. After the judge denied this motion, the judge ordered her to file an answer within 5 days. She did not understand what was happening and reached out to this person who told her that he would handle it, but ultimately did nothing and failed to file her answer. She assumed that everything was going well until she received a notice to vacate on her door. And after he revealed he was an attorney, she reached out to LAFLA for assistance, where I assisted her in setting aside the default and negotiated the settlement. Had she not been able to set aside the default, she would have been homeless and ultimately lost her Section 8 voucher. So again, I'm urging the State Bar and this working group to strongly reconsider its use of paraprofessionals in housing law matters. Thank you.
Thank you. Is that all for public comment? Oh, there's one more hand.
There's one more person, yes. Carol McBurney.
I would like to second that request for reconsideration. Specifically, I am a Shriver housing attorney at Legal Aid Society of San Diego. And in San Diego, we have seen how it can be so detrimental to tenants to not be represented by an attorney, and even more detrimental really than them being improper when someone who holds themselves out as an expert but is not an attorney becomes involved in the case. In San Diego, we actually saw a situation where a non-attorney who was holding himself out as an expert in housing and landlord matters and was involved in a tenants union was encouraging large amounts of tenants to withhold rent. But unfortunately, the proper reasons to withhold rent really weren't there. And the targeted tenants were largely Spanish-speaking population. So what ultimately happened is these tenants who were seeking the advice and, quasi-representation of this non-attorney withheld rent, and there were about, got to be 30 or 40 eviction cases, unlawful detainers that arose from this. Legal Aid was able to get involved in some of them and try to protect these people's housing, but many of them at that point did still end up losing their housing and having to move because of someone who was holding themselves out as an expert in this field. Unlawful detainer law is actually, while it is, summary proceedings, it's actually extremely complicated. You're not just dealing with civil code sections or code of civil procedure, but you're also dealing with health and safety codes. You're dealing with numerous organizations. For San Diego, you're dealing with SDHC, the San Diego Housing Commission, as well as the county for any Section 8 cases. You're dealing with the code enforcement agencies for various cities. You are dealing with a vast amount of new law that is emerging in this area that even a lot of attorneys are grappling with because it is very complex. The way it is written is not quite clear. The legal standards are very complicated. And really there's even split decisions coming out from numerous judges, at least in San Diego. So this is really a developing area of law in the middle of a pandemic. And it really
We have
is
20 seconds left. Thank you.
it is so dangerous at this point to allow people that are not legal professionals and not lawyers to represent in this area. Thank you.
Thank you.
Thank you. We have another speaker, Gilberto Vera.
Hi, yes, good morning, thank you. My name is Gilberto Vera. I'm a senior attorney at—
Oh, sorry. Apologize.
He's still muted.
Oh,
Hello, can you hear me now?
yes, go ahead.
Hi, yes, my name is Gilberto Vera with a senior housing attorney at Legal Aid Society of San Diego, and I wanted to add one thing, that having an attorney represent a tenant is extremely important, specifically in any sort of federally subsidized tenancy, right? The loss of a subsidized tenancy can devastate a household and will almost always lead that household to face imminent homelessness. And subsidized housing law is extremely complicated. It all depends on the types of subsidy, and even then trying to figure out what type of subsidy is used, especially now that it's become more popular to use mixed federal subsidies to develop housing, is made it even more complicated, even as attorneys, to properly advise tenants, and after we've had years of experience. So I feel that specifically when dealing with federally subsidized housing, those tenants would be at great risk if their cases were handled by someone who's not a trained attorney. Thank you.
Thank you.
I don't see any other attendees with their hands raised. Is there anyone else who wish to speak? Okay.
I think Ira's got his hand raised.
Yeah. Since it's a public meeting, I want to say something about the public members, the members of the public who just spoke. All of them seem to have had in mind, and we're talking about tenants being represented by untrained people. What we're trying to do with this program is to require a large amount of training for the paraprofessionals. Yes, it's better to have a lawyer than a non-lawyer paraprofessional, but many tenants can't qualify for legal aid and can't afford a lawyer. That's it.
Thank you, Ira. Okay. Any other questions regarding that? So I was just going to go briefly over the agenda. And Linda and Lee and I talked about this on Friday. And one thing I wanted to discuss was, I know fee caps is a big issue that I think is obviously going to have to be addressed. And we felt that just like the in-court representation, this is an issue that really should be brought up with the working group as a whole. And then from decisions there, we can then meet and discuss it as a subcommittee issue. But instead of us trying to hash it out here where it may get overturned by the big group, we thought, let's not bog down on that issue here, and we can let the big working group discuss that, and then we can always come back to that. The other thing is going over the agenda. Linda and Leah and I discussed trying to find some people that would help address some of the issues that were brought up in our last meeting, and Linda and Leah came up with some people here that are going to speak today regarding title clearing and conveyance and transfer. We had Ian Duncan who's going to come in and talk at 10:30, so in about 15 minutes. And then regarding unlawful retainers, obviously there's a lot of issues that were brought up, and I think things are going to be hashed out, and but trying to hear from experts and people that deal with these issues every day were important. So looks like we have a couple of speakers lined up for 11, Ora Brjovnik and then Trinidad Ocampo, who are both in eviction defense services. So I think that's going to be helpful for us to hopefully make some decisions here.
So Judge Harper, since our first speaker isn't scheduled to arrive until 10:30, but it looks like Ms. Ocampo is here. Maybe it makes sense to hear from her about the issues.
Sure, that'd be great.
Let me just, hold on. And I think this is what how we were trying to frame things.
Yeah.
The policy issues that I think have been raised have to do with whether tenants will have the resources to hire paraprofessionals or whether we're going to further exacerbate the imbalance. And that's something that actually one of our public members spoke to just now. And then the other issue is the whole civil right to counsel movement and the potential to undermine that movement. So, and I think that Ms. Ocampo has agreed to speak to both of these topics. Is that right?
Yes, I can speak to both.
And I'm gonna go ahead and. So Judge Harper, should we go ahead and start the discussion with?
Yeah, I think that's a great idea. So yeah, if we can hear from Mr. Campo, that'd be great.
Okay.
Sure. So am I free to present and speak? Thank you for having me today. So my name is Trinidad Ocampo. I am an attorney currently supervising 2 of the housing programs and eviction defense programs at Neighborhood Legal Services of LA County. As a brief introduction, I started my career with the Legal Aid Foundation of Los Angeles, where for 7 years I focused on housing, eviction defense, and family law as they intersected. I was also part of the initial group of the Shriver Project, which was set out at the LA Superior Court, which, as you know, receives roughly 15,000 eviction cases per year. Following my 7 years, I actually spent 4 years at the State Bar of California in the Office of Chief Trial Counsel, handling complaints and also primarily handling, for a good portion, handling unauthorized practice of law, complaints and prosecuting non-attorneys who had engaged in the unauthorized practice of law. And then I returned back to my roots and am now back in housing and eviction defense work. So to provide some background and context. So as you all may be aware, the unlawful detainer process is an expedited and summary proceedings. So what could happen in a normal civil calendar over several years will happen in a matter of weeks in the unlawful detainer process. I think unlawful detainer cases can be just as nuanced and as complex as unlimited civil cases. And I've had some that extended out for more than 2 years, involving multiple depositions, discovery disputes, and claims and motions. So I think that's important to note. So while it is codified and legislature sets the unlawful detainer process as being a very summary and limited scope proceeding, they can be just as complex and equally involved in as far as litigation goes. With respect to the paraprofessional's role, I've discussed with other managers in the Stay Housed Committee, which is LA County's kind of modified version of the Right to Counsel project, which was unfortunately cut short by the pandemic. And we've kind of looked into different ways that paraprofessionals could fit into these housing or unlawful detainer process. And I think, as I understand, Ira has spoken and said that it's expected for paraprofessionals to receive substantive training in this matter. And I think there may be some areas where paraprofessionals could certainly be of use. For example, with respect to security deposit issues that arise post-judgment or after a tenant moves out, there is very set laws, but also very detailed requirements from both landlords and tenants to secure their rights. And so that's an area where, legal aid attorneys are not necessarily as involved in, and we often give informational packets, but it does lend itself to the small claims process. And I think if paraprofessionals were to work in that setting, in dealing with security deposit disputes that arise among security deposits, something that is lower priority for legal service providers, for the most part, I could see that being definitely an area where paraprofessionals could lend themselves to both landlords and tenants to navigate and understand their roles and responsibilities. Additionally, as mentioned, because the answer process gives tenants such a limited time frame to respond, those 5 days, paraprofessionals could potentially be seen as providing a resource to people that don't qualify for legal services and getting an answer, because filing an answer is extremely critical. And if they don't file an answer and a default is entered, there's so much work that is involved, after someone's been defaulted or a default judgment has been entered, or even if a notice to vacate, which is essentially the lockout order, is issued to a tenant. So I think if paraprofessionals were to focus on making sure an answer is entered into the record, it's certainly much more helpful than nothing at all. And it could be a source of providing some sort of safety net for those tenants in being able to participate in the court process. Additionally, I think that we've seen during this COVID period an increase of plaintiffs' counsel, so landlord attorneys, using the discovery process to the disadvantage of many, many tenants. And as we've tried to discuss and explore ways that a paraprofessional might be able to engage or assist parties in that process, we thought that maybe a limited way of presenting, for example, a declaration for a tenant or for a party in opposition to a motion for summary judgment, motions to compel, or other motions that are brought in the litigation of an unlawful detainer. So I think that was something that just kind of arose during this COVID period, because during the several month term when evictions weren't proceeding to trial, that's where we saw a lot of, discovery being propounded and a lot of alternative motions being brought. However, I think for a paraprofessional, someone not, specifically educated in the Code of Civil Procedure, in litigation practices, providing a declaration by the tenant or by a party in opposition to a motion might be helpful. And that would be like a limited scope way for that person to help have their say and present a counter argument to a court in the appropriate format and in the appropriate way, but not necessarily filing oppositions or preparing the discovery themselves or allowing a tenant to explain. We saw a lot of tenants that were not actually getting served because they live in large complexes. The envelopes were being left at a gate with like 80 other units, and which is subject to theft and just getting lost in the shuffle of the people that come in and out of a building. And so, if someone were to help them with a declaration stating, I never received this discovery, or I didn't understand what this meant, and asking the court for more time to figure out what it meant. So something to that effect, we could see that being ways that a paraprofessional could help, but not necessarily, have to be as familiar with the Code of Civil Procedure and all the requirements of opposing motion and having to engage in all the legal research, which does require much more familiarity with the applicable statutes, laws, and case law that would be required. And certainly we would want, as some of the commentators mentioned, I think there would have to be some certain types of unlawful detainer or housing cases, which would have to exclude paraprofessionals. And those would be involving HUD, project-based housing, subsidized housing, because for the most part, those are priority areas for legal service providers. And so, and across the board, 100% of people that are in subsidized housing are receiving some sort of, are in project-based housing, subsidized housing, or participating in the Section 8 program, they overwhelmingly qualify for our services. And generally, preserving that housing subsidy is one of the main goals of many legal service providers. So paraprofessionals were to identify a case that involves a subsidized housing, a housing subsidy that is involved with a local housing authority, that should certainly be referred to a legal service provider as a case that we should be handling, given the nuance and the high risks that come with the loss of a housing subsidy to someone who is already extremely vulnerable, most likely disabled or elderly, or a single parent that is receiving that type of subsidy. So I think that would be something that certainly we think should be excluded from representation in the paraprofessionals program. And feel free to clarify. My understanding is this program is intended to kind of reach the people that may be just over the limits of legal service providers, or who may not necessarily be a high priority. So I'm not sure if you've kind of carved out that kind of target audience for a paraprofessional or target consumer as a group. But I think if you were to consider the higher risks of those tenants who are receiving subsidies, that should be excluded from the group that paraprofessionals could serve. Lastly, I wanted to a little bit touch on how we see the Right to Counsel project kind of fitting in with this And obviously, similar to legal services, the Right to Counsel project would be aimed at addressing the most vulnerable of clients. So people who are very low income, extremely vulnerable, whether they be disabled, elderly, veterans, single parents, limited English proficient individuals, people from immigrant communities. Those are traditionally the population that is served by legal services. And I think that, you know, in my example earlier, if we were to allow paraprofessionals to assist parties with declarations to oppose motions, to assist them in articulating their side of the story to a court when faced with, you know, potential for sanctions or a dispositive motion that would, you know, basically resolve their case adversely to them, that could be a good idea, a good mechanism as well to hand over a case to a legal service provider in identifying where that issue arises. I think that the Right to Counsel project is incredibly important. And I wouldn't want the paraprofessional program to kind of, or this proposal to kind of undermine that movement, because housing is, you know, something that is very critical. And as you've seen reports that have come out, especially during COVID, what was it, about roughly 40% of tenants that have been evicted have fallen victim to COVID. And so I think in that context, you see housing very closely linked to a person's health and well-being and so many other, and ability to thrive in a community. So I wouldn't want a paraprofessional program to kind of undermine and undercut the need for a program such as the Right to Counsel, you know, Civil Gideon type project. And ideally, there would not be as much intersection when it comes to the intended participants or consumers who would be using a paraprofessional versus accessing a legal services program. So I don't know if you also have questions for me. Yes, Ira.
Trinidad, you mentioned discovery. What do you think about paraprofessionals propounding discovery? I see there, I just looked, I didn't realize there's a judicial counsel form interrogatories for unlawful detainer. I don't know if there's a request for production form, but it'd be easy to create one. And request for admissions, it'd be easy to create that too. So propounding discovery by paraprofessionals and responding to discovery, what do you think?
I think that is complex. I think it's hard because if paraprofessionals were to propound discovery, they'd also have to be familiar with the mechanisms to ensure that that discovery was responded to, in understanding how to meet and confer, or to bring a motion to compel, and for sanctions. And I think when you look at that, you know, and I've seen clients come to us with discovery prepared by a non-attorney. And what happens to it is it just gets lost in the abyss. You know, plaintiff's counsel or landlords will look at this, well, this is just coming from the tenant. And so they take it a little bit less seriously than when it's coming from an attorney. As far as responding, it could potentially be helpful. I think there would have to be definitely some substantive training, but it's also discovery responses can make or break a strategy. And so I think there's higher risk involved there. And I think without knowing the level of detail that's involved in a paraprofessional's training, I think that might be a harder kind of proposal to make, given, you know, would you trust a non-attorney to prepare the discovery in a general civil matter? You know, similarly, would you ask if that would be appropriate? Because there are so many nuances as well.
About propounding the discovery, it occurs to me it might serve the same purpose as what you, I liked your idea about paraprofessionals being able to write answers that would be, I guess, filed pro per.
Mhm.
But they could also serve form discovery as to serve the same purpose as the answer, to give them kind of a safety net
Right.
until they get a lawyer, if they can, represent.
And perhaps with form interrogatories, the issue is with any sort of discovery that you would propound in this type of setting, requests for admissions, special interrogatories, requests for production of documents. They tend to be very particular to what type of eviction is this? Is this based on a nuisance? Is this based on non-payment of rent? Is this based on a breach of a lease term? Is this based on illegal activity in the unit? So you'd have to consider the type, but I think potentially, serving form interrogatories could be something that I think I would want to consider that, or maybe just flush it out a little bit more about what that would look like.
Mm-hmm.
But with form interrogatories that are specific to an unlawful detainer, yes, there are judicial council forms that could certainly be filled out and served.
Thanks.
Looks like Freba has a question.
Good morning, everyone. Sorry I was late. If it helps to compare it with regards to discovery to family, at the Self-Help Center, we don't help with discovery. It's all about strategy. We provide form interrogatories because that's judicial counsel and you can't go wrong with that, right? But anything else we don't help with. When we were discussing discovery in the family law group, it was the position of, for example, litigators like Steve Hamilton, that he has his paralegals do discovery motions all the time. And that is when they learn it is simple enough for them to do. So in family, we decided that written discovery be included as tasks that paraprofessionals could do, depositions not be included, expert discovery not included, but subpoenas, motions to compel, motions to quash, not related to depositions be included. And I was wondering, is there any comparison there at all to make you Trinidad to make you feel comfortable in sort of your position of whether paraprofessionals should do discovery and what limitations should be put on them in the UD context?
Sure, and you bring up a good point. So in your example, you talked about the attorney that lets their paralegal propound discovery and respond to discovery in family law settings. And I think if there were that component or that added supervision by an attorney, certainly, because discovery is very much part of a strategy in a lawful detainer case. But I think there is some risk of harm in that if they respond improperly to a request for admissions, that will bring a dispositive motion. That will bring a trial essentially on the merits before there's a real trial, right? It'll be on the pleadings in that motion. So, and when you think about, I think in family law, there's also a different context, because in family law, you're talking about, sometimes custody and visitation of a minor, or whether or not spousal support or child support will be paid and how much. Those things are fluid. And so as post-judgment, you can always go back and request for modification based on change of circumstances, whether it be for the custody or the visitation order, if someone loses their job and wants to modify the support. However, in a UD, you either keep possession of your home or you lose it. So I think it's a little bit different in that sense, because a dispositive motion based on responses to discovery could result in you just losing your home, So I think that's important to note. But thank you. You do bring a good point, and I do see, having some familiarity with family law, I see there being some differences there.
A quick question, Sukampa. I know the right to counsel project keeps coming up, and you mentioned that you don't want to see a paraprofessional program undercut or undermine that. Can you give me some examples of how that would undermine? Just to put things in context for me.
Sure. If you're creating a paraprofessional project that would be aimed to kind of bridge the gap and serve all those people that are not being served by legal service providers, it could then say, well, we don't need a right to counsel because now we have, this public, this system of legal service providers that offer really low income people, and it's being supplemented by a paraprofessional program for people in the communities to reach out and receive these services. So isn't that, good enough? Isn't that equivalent? But I think what we want to say is, yes, a lawyer is always better. And if, when it comes to someone's housing, whether they may be homeless or not, that we really want, an attorney similar to the public defender model, an attorney in every single UD courtroom to be able to provide that counsel. And I know San Francisco kind of implemented a similar project. Currently, we have Stay Housed LA in LA County, which is actually assigning 1 to 2 legal service agencies to each courthouse so that everyone that has an eviction in those courthouses, has access, if they qualify, obviously with income eligibility, to some sort of counsel and advice, document preparation, or full scope representation. And as I understand it right now, with the low numbers of UDs, we've taken every case that's come to our office. We've accepted every single one person that qualifies. And this is a modified version of what was going to be right to counsel, which could place those advocates in those courtrooms. But for right now, when there's only 5 to 7 matters on calendar versus when there's 30, during regular times, because we're working on a limited budget. So I see that being, the ideal is to have those attorneys there and being able to step in for any qualifying individual versus having some legal services and then a paraprofessional program to supplement that.
Thank you. Appreciate that.
Mm-hmm.
Anybody else have any questions?
Can I ask
Yeah.
a question? Oh, sorry.
No, go ahead, Lee.
I'm just curious if you are familiar with or you come across unlawful detainer assistance, UDAs, in any of the work that you do.
Not as much. It's more often, and I have several stories of more notarios, paralegals, lawyers, what's presented as kind of a lawyer referral program, which is really, they do all the document preparers more so. And unfortunately, when I was as a supervisor in the Shriver project, I did encounter where when I was actually in the Stanley Moss Courthouse, we would get up to 75 people coming per day. And we had an office of 6 or so. And that's where the paralegals would come and kind of poach those clients from the halls of the courthouse and tell people, oh, you don't have to wait, you can come with me. And unfortunately, we saw a client go and end up spending roughly $6,000, their life savings, to preserve their home, only to find that a bankruptcy had been filed to kind of stay the UD case. And then they were sanctioned for filing an improper bankruptcy. And they were out $16,000 by the end of all of that, plus they were evicted. So I think it's more, I haven't seen UDAs being used so much, and those tend to be used more by landlords who are just getting the initial filing prepared. But I do see, in the context, at least in my experience in legal services and also with the state bar, that other people that have some legal training using, the paralegal certificate, the unlawful detain, or the document preparer certificate, or I forget what it's called. They usually get a number. There was one person with a card. I remember at the state bar, I had a case where someone would present their legal document preparer card and actually go and make appearances in court in one of the smaller counties up north. And the court became familiar with that person, but they seemed to not mind because they were able to help them process cases faster. But one person saw it and took issue with it, as they should, that a legal document preparer is not qualified to go and present anything in court. But I think it's anyone with kind of some authority or some title has been able to kind of manipulate that in a way that's disadvantageous to people who are not understanding of what that means. And Amos, you have a question as well.
Yes, thank you, Ms. Ocampo, for coming and talking to us about these issues. I think a number of issues that you raised are things that we're going to need to consider, especially going through the different tasks involved, both in a UD case, but also pre-filing. You mentioned a couple of pre-filing things are separate from a UD case like security deposit, but I think there's a number of other potential things like responding to a 3-day notice or a 30-day notice or a 60-day notice, habitability complaints or concerns, or illegal rent increases. And I think what we need to do is really come up with a list of issues that we want to consider. I think the UD issues that you're raising, we need to consider further. And I think especially the motions and discovery, I think we're separately considering in court what that would look like. So I'd really appreciate it if you don't mind continuing to be a resource for this committee and maybe coming and weighing in when we have even more specific things, and particularly right to counsel. We've talked briefly about this on the committee, but I think if we're going to be proposing paraprofessionals practicing in UD court, I think we definitely need to consider what this committee and working group and what the bar can do to not undermine the right to counsel movement and to understand it. And so if there's specific ideas or proposals from you or from legal services or from people in the right to counsel efforts, I think we'd love to hear from that. The other thing that I'll ask you briefly now, but also I think this is a continuing discussion, is particularly from legal services, but from others as well, there's been a number of concerns and risks that have been raised about doing this at all. The paraprofessional program generally and specifically with respect to housing. And if there's ideas about how to regulate or address or minimize some of these concerns, I think we'd also like to hear about that. And that includes competency issues, training and competency, fraud by non-licensees, excessive fees, undermining the right to counsel movement. And again, there might be others that I think we need to hear about, because I think we definitely need to consider and see if we can address some of those risks. Do you have ideas on things that we should be considering?
Well, I think that certainly paraprofessionals that are supervised by attorneys would be preferable. And especially particularly if you're considering allowing paraprofessionals to litigate or argue in court. And I could see that a parallel between, in the workers' rights context, right, workers' compensation, you have paralegals or certified individuals being able to present arguments or appear before court, but those people are still supervised by an attorney. So if you were to allow paraprofessionals to do that, perhaps you would require still that they be supervised by an attorney, but at a lesser cost. If they're working with an attorney's office, they could still handle those hearings, but that would have to come under the supervision. So I don't know if you all are familiar with the workers' compensation, where you have a representative who is certified or has some qualifications and is working under a workers' comp attorney. They can make those appearances. And because it is such a niche area of practice, they do develop, enough understanding and expertise in those hearings to know how to handle them. But that does come under the supervision of an attorney, as an example. But I do agree. I think I didn't quite touch on others, but yes, habitability issues certainly could be something that could be handled, or habitability disputes, by a paraprofessional. And I know you all are still considering whether paraprofessionals would serve just tenants or both landlords and tenants. And I think based on the model that, as I understand it, if this were to fill like that justice gap of people that can't quite afford attorneys, and I don't see why, landlords and tenants couldn't both use them to some degree, at least in, the capacities that we've kind of discussed. I think security deposits too, most attorneys won't handle security deposit issues as they tend to come up in more of a small claims, but certainly having a paraprofessional be able to advise someone and guide a landlord or a tenant through a small claims process addressing security deposits or habitability issues, I could see that being something that could work. And you have another question, Amos, or comment?
Yes, thank you. I'm wondering specifically in Los Angeles where you practice, for people who either don't qualify for legal services or get limited legal services because of capacity or funding issues, are they referred to a private attorney? And do you have an idea of what the cost of a attorney representation for people who are low income, but for whatever reason are not getting free legal services from your organization?
Sure, we do have, and I've seen this on both the family law and unlawful detainer side, there are what we call low bono projects. So in the UD capacity, there's the Eviction Defense Network, which will look at someone's income and present a sliding fee scale based on their income as to how to charge. And sometimes they'll take those cases pro bono when they see with just the money so tight or if there's some circumstance. And Elena Pop is the executive director of Eviction Defense Network. Similarly, there's Levin and Quinn, which offers similar services on the family law side where they're considered low bono, where they're not free necessarily, but they will charge on a sliding fee scale based on the client's income. And maybe potentially that could be a consideration as you consider fee caps, because if the purpose of this project is to address, people that are above the qualifications over 200% of the federal poverty limit, which is, legal service, that's kind of our standard as to how we can assist people. Similarly, you may look at sliding fee scales for paraprofessionals in how they charge. But yes, we do have a few resources for those individuals that fall outside of our qualifications and eligibility.
And do you know what generally that sliding fee scale looks like? In other words, what's the expected charge that you tell people that they might need to pay?
So for an answer, they may charge about $200. So in considering the filing fee, that might be $400 versus, with an attorney. But we also have a referral to our self-help centers, which we actually provide services, we provide an initial referral to the self-help centers for the answer, but really the representation part or the low bono projects that we refer to are for hearings or for trials. And I should have clarified that.
Right. Any other questions for Mr. Compo? Well, thank you very much. It was really helpful. And as Amos said, it'd be nice to have you as a resource as we move along here. So I really do appreciate it.
Sorry, I do have one other question.
Okay, go ahead, Ira.
Trinidad, do you know, aside from the low bono programs, and they're really limited, does NLS LA refer to private lawyers, like a referral list or something? And how much do they charge a tenant for various things they do?
I can only speak from just some unique circumstances. I know with both legal aid and NLS, there were a list of attorneys that we recognize would handle cases for less than the average. So they might handle a trial date for, $500 or less to appear at trial. And that's to review the pleadings and everything. Like I said, an answer might be about $200 or less. I've seen it as low as, $50 to $75 and as high as $200. But again, we always tell people to use their local self-help centers, which NLS is currently operating 9 in LA County. But I think more than anything, it's when they show up at trial and have to be able to present to the court where a tenant becomes most vulnerable. And even being able to having an attorney there to negotiate on their behalf is often critical. Unfortunately, we've seen people recently go in and negotiate and think they could handle dealing with an attorney and end up with terrible, terrible deals. Whereas if an attorney had been present, it's just, and even in the Schreiber Project, and I think you mentioned that early on, in looking at the Schreiber Project numbers, and I can tell you I've been part of the data collection for that, it doesn't tell all of the details. So whereas, yes, there's more settlements happening, a settlement with an attorney tends to be much more favorable than a settlement without an attorney, ensuring that the record is sealed, ensuring there's adequate time for move out in consideration of any factors such as young children or school schedules or disabilities and challenges in relocating. So I think that's something to consider. And so that's where I think that in my experience, I don't know that I would want a paraprofessional negotiating for a tenant, at a trial date, at least not without more information about what kind of training and I guess education that a paraprofessional would have to be able to get that title and certificate and qualification.
Well, if they got a lot of training, as much as you would want them to have on the issues that come up, and 90% of the, I would think 90% of the settlements in the courthouse on the trial day, you think they can be educated enough for that? I mean, I think there's limited issues that come up. There's just few really critical ones, but like sealing the record. Do you think that the paraprofessionals can be trained to do that?
Potentially. I think right now it still would be best to have them supervised by an attorney if they were to do that, and maybe have some sort of scale. Paraprofessionals without supervision may be more limited in scope, but if they were supervised by an attorney, because they could charge less as an hourly rate, they wouldn't have to charge, I think the market is what, $300 an hour? I know. I mean, I've seen landlord attorneys charge as much as $800 an hour. So yes.
Okay, thank you.
Okay, well, thank you very much, Mrs. Kopp. I really appreciate it. And hopefully we'll hear from you again in the future.
Thank you so much for having me. I really appreciate it.
Absolutely.
Have a good day.
Thanks, you too.
Bye.
So Linda, I know Mr. Duncan looks like he's been on waiting. Should we switch gears and let him present?
Yeah, yes, I think so. And Mr. Duncan was agreed to talk about the issue. There were questions about this what had been discussed, this clearing title as opposed to quiet title. So I had a very helpful conversation with Mr. Duncan, who said part of the issue is the terminology that we're using, and I'll let about in terms of clearing title, and he suggested maybe some difference in terminology that would clarify what we're referring to. But I'll, Mr. Duncan, if you want to go ahead and address the group.
Sure. Hi, everybody. Thanks for having me. My name is Ian Duncan. I'm a legal document assistant, and I presented to your group back a while back in May, June or so about a different subject. Yeah, Linda called and asked about this term title clearing services, and I didn't really know what that was. And so before I go on, I have to tell you, I don't actually have very much time left, but before I go on, can I ask the group, does anybody know if, like, where that term originated before I say what I think it probably means? Does anybody sort of have an idea of what we think we mean by that term?
Yeah, I do. Dealing with title problems short of litigation. For instance, getting the information about it, the papers that have to do with it, and then negotiating with the lien holder. That's part of what I think some others have had in mind.
Okay, so an actual court matter of some sort.
No, short of an actual court matter.
Mm-hmm.
Outside of a court matter.
But where there's an underlying or a possible controversy?
Where there's a possible controversy, a lien that a lien holder might be willing to release through a negotiation.
Mm-hmm. Okay, I understand. That is not something that I'm qualified to talk about at all. It's my my thought was, because neither of us knew what this term was sort of referring to, is that perhaps the working group was talking about just sort of more kind of on a more basic level transfer documents of some sort, like adding a spouse to title, putting a property into one's trust or taking it out. That was my guess, just because I didn't know what the term was when Nancy asked me. So if that's not what was on your radar, then that's all.
Others might think it is, but I wasn't thinking of that.
Mhm.
Sounds interesting, though.
Yeah, it's an area where there isn't really a good service for sort of the middle class type client for this. You know, everybody in the world sort of says go to a title company, but title companies don't do that at all. So then they sort of get stuck and don't really know where to go after that. So
do you think that would be a good area for a paraprofessional to explore?
I do. There's a couple areas where, it really is an area where title companies don't help at all, even though sort of many people in the world sort of have the idea that they do. Title companies don't help with, title transfer services when it's outside of an escrow, or at least they're not supposed to. And so they get to the title company, they say, you helped me buy my house, 10 years ago, and now I've just gotten married and I want to add my spouse to title or something like that. Or I've just gotten divorced and we need to take one of our names off. And there isn't really a good sort of place for them to go after that, after the title company says that they can't do it. They could go to a law office and, really sort of, pay a lot relative to the service that they're receiving, or they could very dangerously try to figure it out on their own, which is sort of fraught as well. So this is an area where legal document assistants currently assist, but it's difficult because I think for two sort of categories. The first one being the more important, which is helping the person figure out exactly how they want to hold title, such as the various methods. They oftentimes will have a book or something like that nearby that'll explain the differences between joint tenants, tenancy in common, the community property and community property without a survivorship. But more meaningful help, I think, in that sort of subject would be useful to the kind of homeowner client. And then just sort of helping with the type of deed that's needed, the perhaps somewhat relevantly, things that recently relevant, sort of the, I don't know if you're familiar with the Proposition 19 sort of, and reassessment and issues like that. I think it would be sort of useful for people to be able to get somewhat meaningful and straightforward help on that sort of thing. So it may be something worthy of your discussion.
Great, well, thank you. Any
Sure.
questions for Ian? Nope, doesn't look like so. Thank you for
Thank
taking
you.
your time. Sorry
All
we
right.
got you late, but we do appreciate your time. And
No problem. Thanks so much. Bye-bye.
Okay, bye. And Linda, do we? I can't tell that the other speaker.
I don't see her here yet.
Okay.
Let me just. Yeah, she was going to join us at 11 and I don't see her. I was checking to see if she's in the list, the group of panelists, and she's not.
Okay, so I guess waiting for the other speaker to come and see if she approves. Does anybody have a place you want to get started here? I guess it's hard for. Go ahead, Amos.
Well, I was going to say, and I made this comment earlier, but it does seem like one thing that this committee is going to need is a list of tasks, somewhat like what the family law subcommittee put together, so that we can really go down the list and consider them. So I don't know if that's something we can put together, staff can put together, or maybe we could reach out to some, to Ms. Ocampo or other legal services to help us put that together. But I think that's a really important starting place.
Yeah, I agree. And I didn't know, had the same question, Linda. I didn't know if that's something that we were going to try to piece together here, or if it's something that we're going to reach out for.
I think the idea was to reach out to subject matter experts on delineating the tasks. And I think, again, making recommendations about what would be included and excluded, and hopefully have them then be able to present that list to the working group and ask questions.
I can help with getting us started, getting help from subject matter experts in my office. You know, just off the top of my head, answer, stay eviction, set aside. And then there are others where the matter gets litigated, obviously. So I can get us started if you like. I would have been happy to do it for today. It just wasn't on my list to do, but I'm happy to do it for our next meeting, Judge, if you want me to.
I think that'd be great. I think that'd be really helpful.
You know,
Go ahead, Ira.
I'll help with that too. If you'll get a start on it, I'll add some stuff to it. I've mentioned this. I've been doing this a lot pre-litigation, so I have in mind a lot of things that need to be done pre-litigation, and I used to litigate these also, so I can add stuff into the litigation part.
That'd be great. And, you know, I do unlawful retainers, but again, I'm only doing them after the fact, so to speak. It seems like the bulk of what a paraprofessional will be doing be up front before it even gets to court, and maybe even keeping it from getting to court. So I think, you know, that'd be great if you guys could start compiling that task list, so to speak. The right to counsel project, I guess, is something I don't really know a lot about. So I guess, I don't know, Amos, I know you brought it up a few times. And I mean, is the idea that they want to provide like a public defender, an attorney for anybody in an unlawful detainer case who cannot afford an attorney?
That's the idea.
Yeah.
Yeah, and I thank you for raising that, Judge Harper, because I do think this is something we really need to consider quite a bit. I initially was inclined to vote against including housing at all in the paraprofessional program, precisely because of this concern of undermining the right to counsel movement. I mean, there's clearly a huge unmet need. And the question is, how should that need be addressed? And there is a right to counsel movement. New York passed a right to counsel. San Francisco has passed a right to counsel. Los Angeles has really been on the edge, as Ms. Ocampo mentioned. Right before the pandemic, there were funding and discussions about funding. Certainly increased counsel, whether or not it technically is a right to counsel was sort of under debate, but recognized the need and importance of having counsel in housing and in eviction cases. There's clearly now data that shows the outcome is different for people that have an attorney than people who do not, tenants who have an attorney and tenants not. And so there really is this growing, it's sort of viewed in the civil Gideon, as you mentioned, Judge Harper. It's sort of like a public defender. In anyone who can't afford an attorney should be provided an attorney, and it makes a difference, and it's an obvious need. Because of the unequal bargaining and unequal playing field. So there really is a lot out there on this already that we should consider. And one of the things I think that where it comes to a head for me is, you know, if we are moving forward with a proposed paraprofessional program, what can the working group do, and what can the state bar do, and maybe the Supreme Court do to make sure that whatever the proposed program is, it doesn't undermine those efforts or funding for those efforts. And I think there probably is some things that we can do. We just sort of have to figure that out.
Okay, great. Thank you. Freebie, do you have a question? Or I know our next speaker is waiting to.
Well, I don't have a question. I just wanted to say that for the Trinidad said a few things that made me think of perhaps we should talk about in terms of limiting the kind of cases that the paraprofessionals can assist with in in the UD arena, including those who qualify for the very low income tenants, subsidized tenants in subsidized housing, and possibly tenants in areas where there's right to counsel. So if you could just make a note of that and discuss that later on as possible limitations.
Yeah, I agree. Right. Thank you. I see our next speaker is here.
And I can make an introduction. This is
Please.
Paraprofessional. She is, I guess, a relatively new director of the Eviction Defense Collaborative, which is spearheading the right to counsel movement in San Francisco. And maybe, Aura, you can explain how the Right to Counsel project, how it manages that project and the relationship with the legal services programs.
Certainly, I'd be happy to do that. Thank you for that introduction. And let me say, I came on early enough to hear Amos speak beautifully about anything I probably would have said. So thank you for what you were just talking about in terms of the tension with the paraprofessional program that you're contemplating and not wanting it to carve inroads into the hopes for the right to counsel movement. So we do have full scope right to counsel here in San Francisco. I'll talk a little bit about how it works and answer any questions that folks have. It was introduced via an initiative process. So Prop F passed in 2018, and it was implemented 1 year later. So July of 2019 is when our full scope right to counsel program was kicked off. Proposition F passed as a unfunded mandate, as the voters of our city love to do. So there was a mandate to provide an attorney to tenants in every eviction case, but there was no funding for it. So the Board of Supervisors did step in and create funding and sent it out with RFPs, and various different legal services agencies throughout the city submitted proposals. And the way the program ultimately developed, our agency, the Eviction Defense Collaborative, is the lead agency, but there are 9 participating legal service organizations within the Right to Counsel program. So as lead agency, we do all of the intakes. We have a very robust data entry system using a jerry-rigged Salesforce program. All of the other 9 service agencies participate in this, and based on different criteria that we created as a group, every case is sent out to an appropriate agency. So Bay Area Legal Aid is our Legal Services Corporation funded agency. So they're taking the very low income cases, mostly the subsidized and Section 8 and public housing cases. We have the AIDS Legal Referral Panel, which will take cases where people are HIV positive. Legal Assistance for the Elderly takes people over 60, disabled, and so on. So each agency continues to have their own criteria. And then EDC, where I am the director, we're the fallback. If there's nobody else whose criteria take it or nobody else has capacity, we take the case. And in terms of who it becomes eligible, any tenant in San Francisco who receives a notice terminating tenancy or is served with a summons and complaint. And the commitment from all the agencies is once a referral is made, they do a conflict check, and if they're not conflicted out, they will take the case as full scope representation, all the way from the commencement of service of papers through judgment. And then we have other more detailed criteria about what's not covered. So we don't cover advice and counseling. We don't cover post-judgment work. We don't cover limited scope work, but we're also anticipating that giant tsunami that all of us are terrified about hitting coming July. And in preparation for not having capacity to meet need, we're creating a prioritization system that will target the tenants who are the most vulnerable. So folks with language capacity issues or mental health disabilities or history of homelessness. We have a whole ranking and point system, and we'll ensure full scope to the most vulnerable, and will vigorously help self-represented people with answer packets and so on, then a peer limited scope at Selman conferences for those folks. So that's the plan come the cliff in July. That's a lot of information I threw at you. I don't know what else you would like to hear about what we do and how we run our program. I have been working with the National Right to Counsel movement that does training. So the fact that Los Angeles is opening it up, that Sonoma is working very hard right now to pass something at the local level that I'm aware of. I do know that, and there's legislation right now in Sacramento. It's not fleshed out now, but there is a placeholder, AB 1487, I think is the bill, to place some type of statewide right to counsel just for in the, not the full civil context, but in the housing area.
Okay, quick question, is it limited by income? I mean, do you have to, if you make a certain threshold, you do not qualify for it?
It's a great question, and quite intentionally, deliberately, there is no income screening whatsoever. There's several reasons for that. One is there were several studies that the cost effectiveness of screening out income eligibility and what that takes at the administrative level does not save enough money at the other end to be worth it. The vast majority of our clients that we help are either low income or very low income based on AMI, adjusted mean income in the area. A lot of the higher end people will screen themselves out and choose to go to private counsel. The excuse the background howling. Let me see if I can make that stop. The joys of working from home, right? This an unhappy puppy. The other concern with income screening was similar to, well, I'll say two other concerns. One is that in San Francisco, we have such a serious affordability issue in terms of housing that even an extremely, somebody perceived as being quite high income is going to be very adversely affected by an eviction notice. We'll have serious trouble affording an attorney. So they'll be too high income to be able to afford, to be able to qualify for the free services, and too low income to be able to pay for the downtown firms. That's, I know, the large empty niche that you're trying to help with your paraprofessional program is the bulk of the population in San Francisco, quite honestly. And because of the way that our housing market works, an eviction for somebody in that niche is just as devastating as for a very low income person. And finally, similar to how our rent control law works, it was very important to not have income screenings because, quite honestly, it's perceived as a less than program. We don't want our clients to think they're not getting real attorneys because they don't deserve better. We want them to be getting a right to counsel that everybody in our city has a right to receive if they're the subject of a threat to the essential human need of housing.
Look, just Amos, I have a question, just a quick follow-up. So in San Francisco, if we were to have a paraprofessional program there, is there a need for that in unlawful detainer cases, or is that covered by your project?
It certainly is fully covered right now. We are having no trouble meeting capacity. One of the difficulties with giving you accurate statistics is our program kicked in so close to COVID. I mean, we launched and then there was COVID. So we don't have the kind of data that we would like to have and we do have some before and after numbers to say that it makes a big difference to have a counsel versus to have pro-per assistance. We have really interesting information on that just from our first 6 months of operating. But this is a long-winded way of saying that right now we're having no trouble meeting capacity. And I don't think a paraprofessional program would be of use. Whether that continues to be true after all the moratorium lifts, I can't as accurately answer.
Thank you. Amos, did you have a question?
Yes, thank you, Judge Harper. And actually, they both tracked your questions. So I have two. One now I think will be a comment on the income guidelines, but the other is about the capacity. So on the income guidelines, I just want to note that I think the San Francisco approach to not having income guidelines for the right to counsel is somewhat controversial, and at least there are some folks that believe that the rollout to right to counsel will have and necessarily will have income guidelines generally. So I think San Francisco is kind of unique in sort of the number of cases and the affordability. But with respect to capacity, I am interested to ask you, pre-pandemic, my understanding is not all cases receive full scope representation. And so right now the capacity really has to probably to do with the moratoriums on evictions. So I'm wondering if, assuming there is capacity and for other cities around the state that have, you know, significantly larger numbers of filings and there's capacity issues, do you think that a paraprofessional could be integrated both into the right to counsel and the services provided by legal services, as well as for those, for whatever reason, cases that couldn't be handled under the right to counsel with a attorney? I'd be interested in just your feedback on that.
Sure. Let me answer both prongs. Your first wasn't really a question, but your comment about the unique nature of our lack of income screen, it's not that unique. It's certainly controversial. I agree with that. But if you look just across the nation, some areas are rolling out a right to counsel with no income screen. And there's a pretty long list of ones that are doing it that way, as well as ones with the income screen. And so both have strong arguments on both sides. And I don't know what the state is considering in terms of, because as I said, it is right now just a placeholder piece of legislation that hasn't been fleshed out. We did not meet capacity prior to COVID. That is accurate. I was not in this position. I took over for Kerry Gold, who is now on the Superior Court in San Francisco. I have very large shoes I'm trying to fill. But one of the reasons was that all of the agencies had not fully staffed up. So when right to counsel was first rolled out, every agency in town was hiring and was clearly not able to meet need without that. We are now fully staffed. So it's hard to say whether it's just COVID that's causing us to be able to meet need, or it's the combination of COVID and being fully staffed. We will not be able to meet need come July if the volume is what everybody's anticipating, because that's also not going to be normal. There's been a dam. The dam is about to break and there'll be a flood. So we have currently a lack of realistic numbers. There will again be unrealistic numbers. And then I'm hoping things will level off to normal, whatever normal looks like in the post-pandemic world. And at that time, we shouldn't have difficulty. Our formula is we expect every attorney who is on the right to counsel program to handle about 50 unlawful detainers per year. And with the number of attorneys we have and the number of cases in California, we should be able to do that. But we won't be able to do it next summer. I can't speak for other geographic areas and what the combination of both what their caseload is like and what their legal service organization's abilities are. We're up for funding again. So I speak with a somewhat fuzzy crystal ball, but we anticipate being fully funded again come July. We're only funded through June. So everything I say is theoretical, but we expect the city to again fund us at the current levels, in which case we shouldn't have trouble meeting capacity.
Okay. Any other questions? Well, thank you very much. I really, it's really helpful for me, especially very educational. So I appreciate it.
No,
I actually have a question.
Hey, Linda.
So the other, besides the right to counsel issue, the other policy issue that we wanted to address is this idea of whether there will be tenants who can afford to hire paraprofessionals, or if we're going to exacerbate the imbalance in representation by providing people who landlords can afford to hire, but tenants can't. And I was hoping that you could speak to that question, or whether you think it would be good to have the landlords, the relatively, not the big corporate landlords, but the mom and pop landlords, or people who might be just renting out an auxiliary unit.
So the fear that I've heard that a paraprofessional program will just ever more skew the imbalance between the unrepresented tenant and the landlord getting assistance, I don't think that is a a concern that I share. A couple of examples I could provide. Prior to implementing our full scope representation program, we had what we call the Housing Negotiation Project. It was a joint project of the Eviction Defense Collaborative and the San Francisco Bar Association and the courts, where at each of the mandatory judicial settlement conferences, we would sort of provide the lawyer of the day to make sure that every tenant, at least at the mandatory settlement conference, could have an attorney. It was not an ideal program by any means. If we just compare our stats on favorable outcomes with full scope representation versus those limited scope cases, clearly outcomes are much more favorable, because basically there was an attorney of the day who hadn't access to any discovery, didn't fully know the case, wasn't going to be there at trial, and everybody knew that. So there was tremendous pressure to take less than favorable settlements at those occasions. But that said, the court, when we created this program, had a grave concern that we couldn't do this just for tenants and not for landlords as well. So the Bar Association made sure that there would also be volunteer attorneys for unrepresented landlords. And I'm doing this anecdotally, I don't have the numbers, but there was like maybe one a month on the landlord side that wanted that free attorney versus 20 a week on the tenant side. So the numbers were extremely different. And overall, just, I'm sure you have access to the statistics that in the unlawful detainer setting prior to our right to counsel program, about 80% of unlawful detainers, the tenant was self-represented. And you could flip those stats. About 80%, the landlords are represented. And of those 20% of self-represented landlords, many are just choosing to do that. From my own experience in being in court with those, they're either attorneys themselves or they're professional property managers that feel that they don't need representation. They already have paralegals on their staff. So I think you're talking about a fairly small volume of attorneys who are going to, of landlords who are going to be, quote, competing with the tenants for these paraprofessionals and their fees. And I do think there is a fairly large and growing population of those who cannot afford an attorney and cannot be eligible for the free legal resources who would want this service on the tenant side. So I have concerns about the competition with the right to counsel. I don't have concerns about benefiting landlords to the detriment of tenants from such a program.
Thank you. Ira, do you have a question?
Yes. Have you run across, I'm going to say very many tenants who would be able to pay something more than a trivial amount for a lawyer? Can you give us an idea of how many, how frequently, something like that?
That is a good question. Despite the fact that we provide representation to everybody in the city, the bulk of our caseload is still very low income. So as I'm talking right now, I'm pulling up some of our stats from that. We did a study about 6 months in, and 71% of our caseload at that time was identified as extremely low income using the San Francisco Mayor's Office of Housing criteria. 16% was low income, 8% moderate income, and only 5% was above moderate income. So translating those numbers, I would say only about 13% would be able to afford even the paraprofessional that you're looking at, and still the bulk of our caseload would still be needing free representation.
Is the 8% in that 13% or no?
Yeah, I was adding the 8 and the 5 together to get 13.
What's the income level for the?
Yeah, I don't have those numbers in front of me. We're fully funded by MOHCD here in San Francisco, so all of our data reporting has to use their criteria. So I would have to pull up how the city of San Francisco identifies those categories, and I could give you those numbers, but I don't have those at my fingertips. But if you looked at the Mayor's Office on Housing and Community Development, they created those categories, and it's based on area median income And granted, as I mentioned earlier, AMI in the Bay Area is higher than many other areas of the state.
Thank you.
Amos, did you have a question?
Yeah, two questions. I think there might be unrelated questions. One is, do you have a sense of what the cost of attorney representation would be other than your program that provides the free service? Like, is it, what would the cost be if you weren't available to those clients for your services? And the other question, which I think is unrelated, is, do you typically demand jury trials in all your cases, or is there a certain percentage or analysis that goes into that?
I'll do the second question first, because that's easy. We do a jury demand in every single one of our cases. If nothing else, because pre-COVID, it got you a mandatory judicial settlement conference under local rules, and 80 to 90% of our cases resolve at that mandatory judicial settlement conference. That's no longer true. San Francisco's not doing those. So we don't get a settlement conference till we get sent out for trial now. Hopefully that will change soon. But there's other reasons we do the jury demand also, just based, even if ultimately it gets waived, it rarely does. Even when we go to trial, it inevitably is going to be a jury trial. The more complicated question, what is the cost of representation, assuming the tenant actually could pay somebody? There's a pretty wide range in our private bar. And the reality is nobody who's using our services really could afford that. But the reason I'm hesitating is, if they have a really strong affirmative case, sometimes a private attorney will take the case at low cost because they want to get the affirmative, which they'll take on a contingency, versus somebody who's going to, sometimes they take a case with the intention to do a move out deal, knowing that there'll be a buyout paid and the attorney will get a percentage of that buyout. So those are ways to pay somebody. I'm not actually advocating for that being a great way to pay an attorney, because buyouts in San Francisco sound like you're giving somebody this huge amount of money, but it's not a huge amount of money when you look at them relocating in our housing market. It's money that will maybe fund 1 to 2 years and then leaving the area or being homeless. So an attorney taking a 1/3 cut of that move out money is impeding the tenant's ability to relocate. But that said, that sometimes gives people access to counsel that they otherwise wouldn't have. But if it's just like a run-of-the-mill non-payment of rent case or nuisance case, or even owner moving case without those kinds of attached resources for how an attorney might make money, they're going to charge them hourly. And you're talking about $350 to $450 an hour probably in this housing market, unless somebody's deliberately, intentionally choosing to take a quote low Bono case. And then how many hours? An absolute minimum is going to be 5 hours. And if you go to trial, so you're talking about somewhere in the range of about $2,000 for an initial retainer to $10,000 to $20,000 if you fully litigate it.
Thank you.
Great, thank you. Any other questions? All right, well, thank you so much for taking time to educate us. This was really helpful a lot. So.
Oh, absolutely. Thank you for all the work that you are doing. And
Thank you.
I'm available if there's other questions.
Yeah, absolutely. Thank you.
Linda knows.
Thank you, Aura, and I'll follow up with you about getting information about how those the moderate income levels relate to income. That will be really helpful. Thank you.
Sure. Take care.
Thank you. So where do we go from here? I know Fariba said she and then Irie said as well that you guys would try to put together maybe a list of tasks that need to be done to file a case or to defend a case for that. It's hard from my perspective. I come, again, I keep repeating myself, I come from a very rural county and a very poor county, and very few of our landlords and very few of our tenants are represented by anybody. There is a legal services in Humboldt County, which is a 2-hour drive west for us. There are some legal services down in Shasta County, which is an hour drive east for us. I think in 8 years I've been doing unlawful detainer cases, I've only seen 2 cases where legal services has come and helped tenants, not any landlords. And so a significant amount of our unlawful detainer cases are people representing themselves. So and I can't speak for all the rural counties because some are closer to bigger cities than we are, but I do see a need for a paraprofessional program or somebody to help these landlords and help these tenants, these cases, because people, even the help that they do get sometimes, when they come to court, they have really no idea what they're presenting. They have no idea how they're supposed to defend themselves. So I do see a need for this. And again, I can't speak for all rural counties, but I know for a lot of smaller counties, definitely it would be helpful. And I know, so that's something we can discuss further as well.
And Michael, if I could just jump in for a second, it is, I think this practice area really does highlight what a big and diverse state we live in, right? Because if we were looking just at the more urban counties where there's a very strong movement, right to counsel movement, which I certainly support, if we were looking just at Los Angeles, San Francisco, and other large urban areas, I don't know that we would include this in our program. And I continue to have some internal waffling over whether we should be including it. I certainly don't want to do anything to come up against the right to counsel movement, but there's also the reality that probably is never going to get representation, at least not in the upcoming years, in the more rural counties. And we don't want to discount the rural counties simply because they have a significantly lower population than the more urban centers. So I think this is difficult. I think it's something we should keep discussing. I think it may impact also, though, the availability of people who want to go get certification as housing paraprofessionals until we have those programs up and running in more rural counties. So, I mean, I have no answers. I just want to highlight some of these issues.
Great, thank you. Amos?
Yeah, thanks. And I agree with that. I think that's why my perspective currently is that we may want to think about in our recommendations to what the bar can do, what the California Supreme Court can do, what the legislature can do, to whether we're supporting the right to counsel, whether what we're doing in some ways is a replacement, which I think we're all in agreement it is not intended as that. And so that we should just be, one thing we can clearly do is be clear in our positions on these issues. And if we have any recommendations about right to counsel or how this should not undermine right to counsel, I think we can and should be clear about that. I also think, Judge Harper, your perspective on the rural counties is wonderful, but I think it might also help to get a judicial perspective from a more urban county, where I think, and the Shriver data certainly supports this, and my experience in Los Angeles supports that, it sounds like it's a very different picture. Landlords are almost always, or certainly in the vast majority of cases, represented by counsel, and tenants in the vast majority of cases are not. And so, one of the issues we need to deal with is this a lower secondary, not as good as an attorney, but better than nothing, and how that plays out with the right to counsel movement and otherwise in sort of what tasks.
So Amos, do you have I don't obviously practice in Los Angeles County, though I know a lot of the folks there. Do you have the ability to reach out to someone on that bench to see if they would speak with us, or would you like me to talk to the PJ to do that?
I'm happy to do that.
Okay, so if it's okay with you, Judge Harper, as chair of this group, if Amos can do that. And
Absolutely,
Amos, if you have any issue, if you could please contact me, because I have a direct line to the presiding judge for LA County.
Thank you.
Yeah, no, absolutely. I think
I'm sorry, I didn't mean to interrupt.
No, go ahead.
I wonder if it would be useful to have a judicial officer from an urban county that's included among the pilot counties. Since Los Angeles is not included in the initial implementation, perhaps it might be helpful to hear from someone in one of those.
And remind me, it's San Francisco and where else?
I think not San Francisco. I think Alameda and Santa Clara are included.
Orange County. Are you talking about a populous one or a rural?
I think in terms of an urban. So
Yeah,
I
Orange
think
County-
Alameda and Santa Clara and Orange, perhaps. Maybe Sacramento was recently added. So maybe it would be helpful to get someone from
Well,
one.
it sounds like we should get Alameda because we're considering them as one of our pilot places.
Right.
Yeah.
Yeah.
Right. So on Alameda, let me find out who's doing, unless someone knows or has a contact there, let me reach out and find out. I can find out very quickly who's handling these kinds of cases.
Thank
Yeah,
you.
that'd be great.
I'll send an email. I'll send a text right now while I'm thinking about it.
Ira, did you have a question?
No, I did, but it is about LA, so we're not doing LA. So.
Okay, does anybody else have anything they want to bring up? I think if we get that, an idea from FREBA at the next meeting, I think we're meeting in a couple of weeks. That would be helpful.
I would
We
get
can
together with my subject matter expert. I was wondering if possibly we could invite her to join the discussion so we can explain the items that we have on that list. It'd be great.
That'd be great.
I'll put something together. I'll send it to Linda. I'm not sure if we'll be violating the rules if I do send it directly to Ira, so I'll send it to Linda. And then
I think actually if it's just two of you, I think perhaps it makes sense if we could set up a meeting with Fariba and Ira and me. And I don't know, is Brady still on the call? Oh yeah, you are. You're there. Is that okay if it's just the two of them?
So 2 out of, yes,
okay.
because there's 4, correct? Sorry, this,
Yes.
what's the total is 4, right?
5.
There's 5 on this group.
Either way, then 2 is fine.
Okay.
Okay.
And I'll invite Joanna, my subject matter expert, and we'll have 2 lists, one for landlord side, one for tenant side. In terms of tasks, we'll do pre-litigation, post-filing, and all that. I also wanted to just put this out there that anecdotally, what we see in our county is certainly there are cases that get litigated, habitability issues, all of those cases, but mostly we're looking for our county, we're seeing a lot of abuses in the hallways on day of court where tenants are forced into these really unfair stipulations by those few attorneys that represent all of our landlords, 90% of our landlords. I don't want to name names. I'm not saying they're all bad. I'm just saying to the extent that we are going to empower these paraprofessionals to negotiate and be able to be out there to, kind of give that power to these tenants to not be forced into these unfair agreements. I really like to see paraprofessionals do this kind of work. And our legal services people are not meeting the need, unfortunately.
Amos?
If I can just ask one thing to be included potentially on your list that you're putting together that might not be obvious is rental debt that is now going to be collectible in small claims court. I think that's going to be a huge issue and it's new for the COVID.
Right, they're definitely a new category, absolutely.
And the threshold's pretty significant too. I think, it's over. Yeah.
And I don't think small claims is one of the areas that we are even considering because attorneys are not allowed, obviously. But in terms of prep work, I just don't know if it needs to be a new committee or could we discuss it here, especially with this new way that landlords can go after unpaid rents. Because they could always go after after additional damages done over and above their deposit, and tenants could go after landlords for deposit not returned and all that. So I'm thinking there is a need there for prep work.
There's a lot of housing issues that go to small claims court, and security deposits is I think a big portion of the calendar oftentimes in small claims court. And now I think the rental debt will be.
Right. So I don't know how do we address that, but I also wanted to put that out there. And I'm done putting things out there.
And I think we should talk too about, I think the federal subsidized housing is obviously a huge issue to talk about excluding from this. So that's something I think we should start to decide what should we not have in this program as well. Go, Ira.
Another thing that's like that, I hate to say this, but I have to, is rent controlled housing. Losing that is just as big a deal as losing subsidized housing or government run housing.
Okay. Yeah, so I think it's worthy of a discussion of things that really maybe we should, look at to exclude, so we can start to narrow down what it is our paraprofessionals really should be handling.
Well,
And
I wonder if we want to turn back to the legal services programs, because one of the things they said, that Ms. Ocampo said, is that they will always represent people in subsidized housing because they always qualify for their services. I wonder if there might be people in rent controlled housing who wouldn't qualify for legal services. So if they're excluded, they might not be able to get representation anywhere. They might be excluded from representation by legal services programs and then wouldn't have the access to paraprofessionals.
Yeah.
So
we should get an answer to that question, yeah.
And then on the landlord side, in terms of excluding, perhaps landlords, commercial buildings, multi-units and things like that, we need to consider as well.
I know for sure that a lot of tenants in rent controlled housing are not real low income, sometimes not low income.
I wonder if there's a need to specifically exclude people, landlords who own large commercial or multi-unit housing, or if they're just going to exclude themselves.
Yeah.
Something to consider.
And a lot of times those places have attorneys on retainer who are going to just handle these cases for them too, so. Okay, anything else anybody wants to bring up today? I think we have kind of a good list of things to talk about next time.
Right.
Any
Thanks so
other...
much. I think this was a good meeting.
Oh, I have one thing to add.
Go ahead, Ira.
I think I read in the LA Times this weekend that a lot of people who've left San Francisco and San Francisco Bay Area have moved to your county, Judge Harper, and surrounding counties, but I think they named yours.
Yeah, we are definitely getting the benefit of COVID. People, now that you can work remotely, I think they're realizing they can come up here, and our internet is just good enough to be able to work remotely. So. All right, anything else anybody wants to bring up for today? So our next meeting is on the 22nd, I think from 1 to 3.
Thank you.
All right, well, thank you all very much, and really appreciate, Linda, the speakers. I thought they were really helpful and really kind of, for me at least, educated me quite a bit.
Excellent, thank you so much.
Bye.
Bye, everybody.
All right, thank you all.
Bye.